It's webinar time. Welcome. I'm Chris Irons, former Commissioner for Body Corporate and Community Management, Strata with Hines Legal. With me today, as always, Frank Higginson, partner, Hines Legal. Frank, welcome.
Hello, everyone. And so you can see Chris is not in his usual spot, nor am I. I'm trying a stand-up desk today to do this webinar. So if I move around, it's because I'm not sitting down.
Classy, very classy. I'm at an event for prospective and new on-site managers today. They're having a training day with our good friends at Arama. Been going well. But anyway, we're not talking about that. Although what we are talking about, I think, Frank, it's kind of relevant, isn't it?
It is decision making, and again, we've got a whole lot of content to get through here. But I suppose maybe excuse the blasphemy for any of you that might be that way inclined, the goddammit element. But yeah, this has come from really something that Chris did a while back to a group of body corporate managers that I thought was just a spectacular presentation. So as much as I'll be doing a little bit of talking today, won't be anywhere near as much as what the usual.
We're doing talking.
No, won't leave it all to you, mate. But yeah, like committee decision making.
Yeah, and look, I think, I don't know about everybody watching this, and I don't know about you, Frank, although I suspect you are the same as me in this regard. I'm a person who likes decisiveness. Just make up your mind, do it, live with the consequences. The biggest example of that is when you go out to dinner with people and they look at the menu and they can't decide. That drives me nuts, Frank, nuts.
Mate, I was going to actually use the line at McDonald's. How do you possibly get to the front of the queue at McDonald's and not know what you want to eat? Like, seriously. But anyway.
But to be fair, decision-making is a tough business, and it can be a very tough business. And when you talk about decision-making in a body corporate context, and particularly for committees, it's really tough stuff because you've got all of this legislation, you've got all of these potential consequences on you. And sometimes you just don't know how to do it or where to turn. Well, today we're going to try and break it down for you just a tad. Don't forget, everybody, register for these events in advance. That's how you find out. We'll be releasing June's topics next week. We've got some doozies already lined up for that. Fire us some questions today on the live chat. You can also do that afterwards as well. Got a couple there already. We'll try and get to as many as we can as possible. Let's talk about why decision-making is tough, Frank.
Well, I suppose, it's
decision-making difficult.
Yeah, well, one of the things is, like decisions in business, in a sense, are a little bit easier because there's actually something in it for you. You know what I mean? If I've got a misbehaving employee or a job required on or whatever, there's a financial return to me in managing that. In body corporate, it's not the same, obviously. We're dealing with potentially a whole bunch of emotional issues. And for those reasons, sometimes decisions can be let go. And I mean, the starting point is that even from a committee perspective, there's actually not even a statutory obligation to meet. We have an AGM once a year, but there's no actual required number of committee meetings in the modules. So in theory, as a committee, you can meet once every 12 months, you can meet once a year. It's really up to you. I suppose you can do a whole bunch of stuff on Box, votes outside committee and all that sort of thing. And I suppose we wrote a newsletter on that, Chris, which you might sling up there at some stage. But yeah, it's sort of the starting point is that the legislation doesn't really provide, to a degree, a compulsory framework for committee decision making in itself. So in that sense, to start with, it really comes down to each individual committee to organise itself around what it's actually going to be doing.
That's right. And then we get on to probably the biggest issue of all, Frank, and it's fear, isn't it? Fear of making the so-called wrong decision, fear of a backlash from an unpopular decision. That's very much the case in politics, isn't it? Which is a nice plug for a forthcoming webinar. Stay tuned for that one, everybody. You see it in politics all the time, don't you, where you have the leader, I won't name names, but you have somebody who's afraid to make a decision because they don't want to be seen to be making a decision that won't be popular. It's the same in a body corporate. Even if there's a decision that has to be made, particularly if it's going to cost a lot of money, that's an unpopular decision with all the people voting. So there's a lot of fear that goes with decision making as well.
Absolutely. And I suppose in a body corporate context, you can't really call a plebiscite when you don't want to make it, can you?
No, you cannot. Another aspect of where decision-making goes wrong is that sometimes people, in their efforts to make decisions and try and make them quickly, they go to a snap judgment without having taken the time to gather the information beforehand. And you can understand why that's the case. Quick decision's a good decision, blah, blah, blah. Not always, though, Frank, is it? In particularly corporate land.
No, and we're, committees are volunteers. Usually, well, not usually, depends on, not usually, there's always something going on outside the body corporate environment, so be that a business, family, or other issues. So in that voluntary aspect, it's very easy to, I just don't want to think about it, just do that. And I suppose the biggest example of that we probably see still repeatedly now is no to pets. Just no to pets. So, and again, we're back to committee decision making needs to be based on reasonable grounds. So if it's not, then it's going to potentially be overturned. And the whole we don't like pets or we've got a no pet policy and that's the deal is exactly that. No, don't even ask the question. We're just going to say no. Yep. So that's that type of example.
Yep. Another way in which decision making goes wrong. Sometimes it's actually difficult to get people together, isn't it, Frank? Even virtually, it is difficult to grab people. If you've got a committee that's made up of people with busy jobs, actually getting them together to even answer an email and say yes or no might actually be a tough call, mightn't it?
It is, and it's sort of hurting the cats to a degree. So I think probably technology has got that part to play here in terms of, we're on the bloody things. So, when you have that prompt, that push notification, so you'd say committee decision making, if you're going to do it remotely by some sort of technology, will obviously be a better way to do it. But again, people have other things to do. So it is the gathering together and then the discussions, because I suppose part of it is, part of the reluctance, I think, sometimes to make decisions is just the nature of the decision that you've actually got to make. This is back to trying to please all of the people all of the time is never, ever going to work. And particularly in some decisions that committees can make, that they can affect what goes on inside a scheme, and some things can be particularly contested and emotional. And so it's very easy to sort of defer that decision or not want to make that decision or simply ignore that email about that decision. Now, the legislation's done a little bit about that, which we'll talk about in a minute, I suppose, Chris. But if it's a difficult, problematic, contested decision that's been going on for years, the ability for people just to go, I don't even want to think about it, is always going to be there. And that's just the reality. It's like, you've heard it. I'll tell everyone the story for a second. The phrase, Mark Twain had a great saying, if the first thing you do each day is eat a frog, your day is only going to get better. So one of the ongoing jokes that I use all the time with everyone in the office is eat that frog. So we've all got jobs we don't necessarily want to get our teeth into, want to deal with for whatever reason, get it done, get it out of the way, and suddenly the pressure disappears. And the same applies in a body corporate context. It's not usually, most of the things that committee's been asked to do aren't going away. That decision's still going to be there.
So just to link up there to that an article that we previously written about Clayton's committee meeting. So that link is now there in the comments. And just to comment there about maybe a few problems with my sound. Thanks, Mr. SMB. Doing the best that I can from this end. Not really much I can do with it here. Hopefully, though, people can at least hear me well enough to keep going. Just a couple of really quick other things about why decision making is difficult. Decision inertia is a big one, and that's constantly delaying or putting off a decision because it's not appealing, just exactly what Frank said. Other times the problem is less about decision making, it's more about the communication or the implementation of it. That's a really big one when it comes to reasonableness of decision making. And then finally, the timelines for the committee in which to make legislation have certainly been problematic in the past. That's been changed by the new legislation, which started on the 1st of March, and we're just putting a link up there at the moment to our webinar, previous webinar on that. We can get a bit more information. But look, okay, so that's where things struggle. And then let's talk about, let's talk about our best practice guide. Established right from the outset, though, Frank, pretty much the only job of a committee is deciding, isn't it?
It is. When you actually step back and look at what the legislation requires, it is to make decisions. That's it. And on what and in what framework and how they're based is they've got to be reasonable. And that's really it. So I suppose you look at sort of the nanny state sometimes that we have concerns about in terms of regulations and obligations and prohibitions and restrictions and all that sort of stuff. In a sense, other than when it comes to restricted issues, committees in Strata land almost have an unfettered right to go and do what they want. And how they run their business and how they run their body corporate is really up to them. It's quite extraordinary when you step back and think about it.
Definitely. And look, I know, Frank, you and I have come across these things all the time, but there are a few things which commonly come up from owners asking the committee to do certain things. And here's a quick list of the sorts of things that, as we see it, a committee is not established to do at all. So committees are not there to investigate. They're not there to discuss. They're not there to research. They're not there to workshop. They're not there to answer questions, I don't think. They're certainly not there to educate owners. And they're not there to educate itself, although, of course, they really should be doing that all the time. Now, I want to stress, all of those things are what individual committee members should probably be doing as a matter of course. But at the end of the day, the only job the committee as a whole has is to decide.
And there's nothing in the legislation at all that says the committee's got to investigate proposals, as an example. What the legislation says is the committee's got to make decisions. So, that age-old demand from owners for the committee to do this, that, the other, if the committee's willing to take that on and investigate a particular something that might be solar, hot water, or whatever it might be, then that's completely up to it. But if the committee chooses not to, then it doesn't have to. It's quite interesting. So we're not saying committees can't do those things. They absolutely can. But in terms of whether they're obliged to run around and do all those things, the answer is probably no. So you almost say in a vacuum, if a body corporate committee was elected and through the course of a year, there was nothing that came before it as a decision, PET approval or otherwise, it doesn't have to do a thing. It's really quite interesting. But most people don't put their hands up to go on committees to sit there and do nothing, which generally means all of those things get done. But it's just important to understand from a legislative perspective the differences with what we're talking about today.
And look, before we get into our 6 best practice tips, yes, there are 6. Another thing to keep in mind, individual committee members don't decide on behalf of the committee. It's a majority decision. So the chairperson doesn't have veto power, for example. And for example, it doesn't have power to decide if the committee can't get together or meet. Committee decision-making is group decision-making. It's not the secretary speaking on behalf of the committee. It's not the treasurer making all of the financial decisions. No, it is a joint decision taken amongst that group of people. There can absolutely be a spokesperson, and absolutely best practice demands that individual committee members have responsibility to go off and find out details about certain things. That's division of labour, if you want to get a communist about it for a minute. But at the end of the day, the decision is made as a group. The flip side of all of that, Frank, and conscious before we get to our 6 best practice tips, but the flip side of that is that owners in particular, and then contractors as well, they have a responsibility to make sure that what they're asking the committee to do is something the committee can actually do and decide. That's right, isn't it?
It is. And I mean, this is one of the things that keeps us busy all day, every day, and will continue to do so. So just because owners should understand what they're asking the committee to do, it doesn't mean they're going to. So part of these things is sort of really educating committees around how they should respond to things when owners don't present it in the right way. And even that's back to subcommittees. Like a committee, in effect, can create a subcommittee to run off and have 3 people investigate that solar hot water meter reading, whatever it might be. But ultimately, they'll go away, they'll do their research, they'll come back to the committee as a whole and say, okay, I think this is what we should do. And if the committee as a whole then ratifies that and says, yep, let's go for it, then away you go. So, yeah.
I know we said there were 6 best practice tips, but the first threshold issue is, does the committee actually have to make a decision? Is it something the committee can actually decide upon? As we've talked about in previous webinars, there are certain things that committees cannot decide upon, and they are what are called restricted issues. So the very first question is, does the committee actually need to decide this? We're going to talk about our best practice steps as though that's already been established. So it's been established that this is indeed an appropriate decision to make. And that's always a part of good decision making. And again, it's a part of politics as well, isn't it, Frank? Knowing when it's yours to do and when it's yours not to do. You've got to know where that line of responsibility sits. All right, here are our patented, not really patented, but kind of, here are our 6 towards better decision making. So step 1, Frank, define the problem.
Understand exactly what the problem is. You know, it's sort of, and that sounds rather obvious, but it's actually not. So it's actually understanding what the issue is that is giving rise to the question before the committee itself. Now, that may or may not be actually framed in terms of the correspondence, request, demand, whatever it might be, that's come from the individual concerned. And certainly if you're a committee, it's what are we actually trying to solve? What are we being asked to do? And is that actually the problem itself, or is it something else? And I know the more we spend time talking to clients, Chris, collectively, the pair of us, it is extraordinary the number of times that people come to us with a problem. And by the time we drill down a little bit, well, actually, no, that's not your problem. This is your problem. All the time that happens. And it, again, sounds, well, it is. It's a six-step process, but it's understand what the problem actually is that you're being asked to deal with.
Let's use an example about noise, Frank. So let's just say owner and occupier puts in a complaint to the committee about noise, and it's just simply, I want something done about the noise in lot 10. When presented that way, it's actually pretty difficult for the committee to do much about it because there's nothing there to do with it. But if it's mapped out, if the problem is defined in terms of the owner of lot 9 wants the committee to issue a contravention notice against the occupier of lot 10 for a breach of bylaw X, then suddenly, once you do it that way, it's like, okay, that's what we're actually deciding upon in this case, isn't it? But that's what we mean by define the problem. Rather than just throw a bunch of words on the page, step back, separate it out. Ideally, that would already be done by the owner or the occupier as part of their request or motion. No, that's your first step. And step 2, ordinarily, who would be responsible? So ask yourself, okay, and this is, I think, Frank, particularly relevant in maintenance related. Who is ordinarily responsible in this particular case? So you might have an example where you know that the body corporate is responsible for maintaining common property. So the committee might take an interim view that the body corporate is going to be responsible. And in fact, that idea of taking an interim view or an initial view is actually a reasonably fundamental part of decision making at law, isn't it?
Absolutely. It's just sort of that, it's that this initial assessment. And so using that same example, if the common property is the lift or the driveway into the basement, then it's almost, well, it's going to be the body corporate's responsibility. Where a lot of the disputes come from, particularly in building format plans, is water leaks, maintenance, planter boxes, and it's not, and particularly where there's boundaries, is that common property or is that someone's lot? So at that stage, it might be, well, hang on a minute, we're not sure who's responsible. And that's where you might refer it away to actually try to understand. We've been asked to address this issue of water leakage, but we're not actually sure who's responsible for it. So, Heinz Legal, can you please help us find out where the responsibility for this particular issue lies? Because that then gets into the next step, I suppose, in terms of accepting responsibility if it is your problem, or educating the people whose responsibility it is that it's theirs.
And just to stress, we're not saying you've made the decision at this point. We're saying you've taken the view. You've formed the view that based upon what we know about these kinds of situations, we think the body corporate is responsible. Now we need to be sure about that. So that's when we progress to step 3. What are the variables? Frank just touched on this. And nice segue there, Frank. What are the variables? So sure, the body corporate is responsible for maintaining common property, but is it clear that the fault is actually with the common property? For example, has the owner failed to maintain something, or has another owner failed to maintain, and that's led to the issue? The really classic example here, Frank, is termite infestation. It's a good example to use. So ordinarily, if the termites came from common property, you'd expect that to be a body corporate responsibility. But did the infestation come from a lot owner's lack of maintenance of their lot? If so, and those termites have then come into your lot, perhaps it's actually the lot owner in that case that's going to be responsible. So,
Are there mitigating circumstances? Is a third party potentially responsible? And that's where we get building defects. You know, is it the developer? Is it the designer? Is it the architect? Is it the builder? You know, there's this whole, the body corporate might be responsible element, which is fine, but then is there the right of indemnity or the right to recover potentially from someone else? Part of the matrix that needs to go into the decision making.
leads us nicely to step 4, and you've already talked about this to some extent, Frank. Get the expertise. So if those variables have left things ambiguous, resort to somebody who has the expertise to advise, and it's very unwise to rely upon your own opinion in these kinds of things. It's the rough equivalent of Googling, using Google to diagnose if you've got COVID. So think of it this way. If there's a dispute, you want to make sure your position is defendable every time. The best way of doing that is having somebody who's got some credible authority to say so. And I've said this so many times, I know it's a broken record sort of thing, Frank. Water ingress, get an engineer's report. Legal issue, seek legal advice. Financial issue, seek accountancy input, and so on. So get the expertise. And then that leads us to step 5, form the position. So you've gone through all of those preceding steps. Now, this is logically the point where you finish up. The expert advice has told you that the body corporate is responsible because of a failure of maintenance on common property, and that's the position. It would be very unwise, wouldn't it, Frank, to ignore that?
Absolutely. You know, and more importantly, probably unreasonable is the interesting word. And, you know, in terms of, you know, back to the expert report thing, yes, that costs money. That's the reality of it. And, you know, the Commissioner's Office still offers the free phone call service where you can ring in and probably get some guidance around directions of legislation and that sort of thing. But the Commissioner's Office doesn't actually provide advice. And I suppose, well, Chris, you would have lost count. I've certainly lost count of the number of people that have emailed me to say, the Commissioner's Office said this. And it's like, that might be fine, but what did you tell them?
Yeah.
Because that's the, you know, the input will drive the output, and what the Commissioner's Office has been told is a particular factual situation may not actually be correct, which is always a dangerous thing. So this is why, you know, in a sense, getting advice from any expert is a form of insurance for a body corporate committee.
Definitely. That's a really good way of thinking of it, Frank. Wish I'd do it. And then that leads us to steps. And oddly enough, it's make a decision. And at this point, it's actually the easiest step of the lot. It writes itself. The decision is based upon the position you formed in the previous step. The committee decides to authorise works. The committee decides not to authorise. The committee declines. The committee refuses. There's always got to be a verb in there, Frank. There's always got to be an act.
A doing word.
Doing word. So the committee decides, the committee approves, committee refuses, committee declines, committee authorises. The committee has actually got to do something. That's what constitutes a decision. And as I say, by the time you get to that step, if you follow the previous 5, we reckon at that point, it's cake.
It almost does itself.
And there's something going on here in the background. Hopefully all is okay. Yeah, it is. So a couple of questions here before we go on to try and wrap it up. Mr. SMB, I know you're becoming a bit of a regular with us. Our committee is thinking about proposing the engagement of a body corporate manager, as if a body corporate manager will be making decisions in their stead. Does that actually happen? Yeah, it does actually happen.
But it shouldn't.
Happens quite a bit. It does. There are...
Oh, yeah. Are we talking part 5s or are we talking delegation?
Yeah, there's a couple of possibilities there, Frank. So delegation is one thing, and the one thing that Frank was talking about here that shouldn't really happen. There's such a thing as a Part 5 agreement, which is actually a mandatory step where the body corporate manager becomes the committee. Your scheme has 85 lots. I'd be very surprised if an 85 lot scheme could not muster up a sufficient committee.
Three people. Yeah. So, and once you've got that committee, the committee's the one that makes the decisions. And in Queensland, it's very clear. Committee can't delegate decision making to anyone else. The committee makes the decisions. Same as it's no different to the subcommittee example we used before. So yeah, body corporate managers will advise, support, but they shouldn't be actually making decisions for a committee at any stage in Queensland unless they've been appointed under a Part 5.
Yeah, definitely. Question from Sandra. Sandra, thanks for tuning in. If a non-executive committee member knows his motions will be defeated in committee meeting, can he email all owners, table his EGM motions, collect tally votes in an attempt to bypass the main committee? Well, yes. Yeah. That's
And
what we're talking. Go ahead, Frank.
I was going to say, wait for next month's topics.
Yeah, because what you're talking about there, Sandra, is lobbying. And yes, absolutely, they can. And then another question, Julia. Hi, Julia. I know you're a regular. Thanks for tuning in. Julia, what if you have conflicting engineers' reports because the responsible lot owner has a mate? Well, it doesn't matter if he's a mate or he's not, although that ideally should be declared. But at the end of the day, if you've got one report saying owner responsible, and you've got another report saying, no, body corporate responsible, the decision maker is going to have to resolve that, and the decision maker is the adjudicator at the end of the day. If you're suggesting that the report from the owner isn't valid because it's done by a mate, you'd have to demonstrate why. So simply because they're a mate is one thing. And if they're a qualified engineer and they're qualified to make those statements, that's okay.
And differences of professional opinion pop up a lot. And that's one of the unfortunate realities. So even if you go through this decision-making process, you might go get 3 reports on a particular issue and they all might say something different. That can happen.
Someone has to decide, and that is the decision maker after that. So from the committee's point of view, let's just say the committee commissions a report and then there are 2 others and you've got 3, which are all different. The committee at that point, the committee still has to decide based upon the advice in front of them. And then it's up to that to be challenged after the event, if necessary. Let's sum it up then. Back to those fears that we talked about earlier. Some reality checks to finish off in the very short time that we've got left. So we've addressed those fears of decision making earlier. Here's a couple of realities people need to be aware of. There are very few instances of penalties under body corporate legislation. There's no fines. There's no naming and shaming. Adjudicators won't scorn you in decisions if they see that you've gone through some methodical steps. But if, however, you make crazy decisions without any basis for doing so, yes, you probably will get scorned. It happened and it will happen. Making a decision which later turns out to be misguided doesn't mean that you're a breach, it doesn't mean you're ineligible to be on the committee, and it doesn't mean that you've breached the code of conduct. It just means you made a decision which later on turned out to be not the greatest because other factors have come to mind. I actually think, Frank, and I think you'd agree with this, it's actually far more damaging if you don't make a decision.
Because that looks like inactivity, doesn't it? It looks like you're sort of sticking your ostrich approach to decision making and sticking your head in the sand. So again, you follow those steps and the decision might be, I mean, maybe there is scope to not make a decision, but I think it's probably very unlikely that's the case. Usually it's a yes or a no at the end of the day on whatever this position you've got. And the other thing that gets popped up from time to time is personal liability. So Chris will pop up a link to the section of the legislation that basically says committee members who act in good faith and without negligence are protected from personal liability in the performance of their duties. So good faith, so again, you're not doing dodgy things for your mates, without negligence, and ultimately every committee member should have office holders insurance as part of their body corporate policy, so that if there is some claim against them personally, that they're actually insured for it. But it's really important to note always that statutory protection doesn't apply to defamation. They've specifically carved that out, obviously for very good reasons. So again, another bit of best practice advice is use unemotional words all the time.
Easier said than done.
No name calling.
No name calling. Look, to sum it up, I realise that it's a reasonably simplified step-by-step approach, but I reckon it actually works. And at the end of the day, decision-making here is not about simply saying yes or no to something. It's about saying yes or no, or a qualified yes or no, based upon the best possible information to hand and within the circumstances at hand. It's also about making it in the time frame that best suits the circumstances. Most body corporate decisions, most committee decisions now have a time frame around them. There is capacity to make emergency decisions, and you just got to be careful about what is an emergency in those cases. And probably the final point, Frank, we've talked about all of this as committee best practice decision making. I reckon those steps apply to pretty much anyone in a body corporate. If you're an owner,
absolutely,
manager, on-site manager. Apply those steps to your decision-making process.
Yep. It does, and it helps you give a whole heap of clarity. And I mean, even we're going through a whole of firm SWOT at the moment, you know, strengths, weaknesses, opportunities or threats, and we're going to be applying the same decision-making process to the issues we have as a firm in terms of, okay, that's an issue. What do we look at and what do we do from here?
That's it. Again, we really whizzed through that one today. This is probably one that I think would be really good for people to come back to and watch a bit later and go through those step-by-step processes. And we'd be really keen to hear from people if they have actually decided to apply that and how it went. Good and bad, please. Yep. It'll all be good, of course. Don't forget to register. We will be sending out the June topics next week. We think you're going to like the June topics. I mean, I know you like all of them, but we think you're really going to like the June topics. We've got a couple there that we're really looking forward to. I think
that will be quite entertaining.
Yeah, not that this isn't entertaining, but more entertaining. For now, though, thanks everyone very much for tuning in as always. We really appreciate it. Frank, thank you.
Absolutely. Thank you, everyone. See you next week.
Thanks, everyone. We'll see you next week. Bye-bye.
Bye.